What if I told you that silence, the delay, or refusal to respond can be turned into your greatest legal weapon if you know how to document dishonor? In this video, I'm going to be breaking down what dishonor actually means in law, how to prove it using proper documentation, and how to turn it into leverage during a court battle or a private remedy process. I've studied the UCC, trust law, administrative enforcement, and I'm going to show you how to move from defense to offense just by recognizing dishonor and holding them to it. Before we dive into this video, remember to hit the like button, remember to hit the subscribe button, tap into the community, and stay in the environment. Number two, this is not legal advice. This is not financial advice. Remember to do your due diligence, okay? I think that a lot of times people tap into these videos and they don't look at all the groundwork. They may see something that excites them. They start going to take action, and then they fall short. And then they blame the creator or the person that is passing the information on to them. But I will always suggest you not to just trust me, but to actually find the truth for yourself. I don't care if you're on TikTok, Instagram, Twitch, online. And everything that I teach is more to have you thinking outside the box. Sometimes people may look at this and they don't necessarily need to take action, okay? But to know exactly what is going on behind the scenes and how to put yourself in a position of where companies, banks, debt collectors are not taking advantage of you, I think that what we're going to talk about is help you to be able to do that. So make sure you stick all the way to the end, because what we're going to be talking about specifically is when the companies ignore you. And I'll always talk about this in all my videos at some point, but I figured let me go ahead and make this dedicated video. So anybody who says, okay, what should I do next? Or how should I respond when I do a debt discharge, or when I do use a negotiable instrument? How do I enforce it? Okay. And how do I call them out when they are doing things like ignoring me or dishonoring me and so on and so forth? So this will be that video for that you can come back to and, be able to get that information. So what is dishonor? Okay, we'll just dive straight in. If we go to UCC 3-501, okay, look at presentment. We go to UCC 1-202, talking about notice. And then we go to UCC 3-505, evidence of dishonor. Okay. The first thing I want to cover, all right, is dishonor typically happens when a party fails to respond, rebut, or perform within a required time frame. So if you agree to pay for something, or you agree to a contract and you don't perform on that contract, then that is dishonor, okay? So on their end, they'll say that you agreed to pay because that's what the contract says. That's what you signed off on. But when you don't pay it, they're going to flip the script onto you and make you feel like you dishonored. Okay. But then there's other foundations of contracts where they also have to perform as well. So one of the things that are important to a contract is the documentary evidence, any terms, information about a particular loan or contract, things that must be clear and conspicuous, right? And then there's elements of the UCC and the USC where you can ask or demand for particular information. And that's a way of forming a contract as well, okay? Dishonor also happens when you submit lawful tender, notice, or offer, and it gets ignored or refused. So when you send a conditional acceptance, or if you send a conditional offer, right? I conditionally offer you X amount of money to pay this balance or whatever the case may be, and they ignore it or refuse it without any true legal explanation, then that would be considered dishonor, okay? Or if your claim or affidavit is left unrebutted, okay? For an example, if you send an affidavit of truth and you lay out some statement of facts that you know to be true and it goes unrebutted, then everything that was said there stands in truth, okay? The whole point of understanding dishonor is if you don't perform based off of in alignment with contracts, okay, meaning that you submit an offer, you present you send them a presentment and it goes not responded to, if you don't pay your bill or perform on your contract, if you send an affidavit of truth and they just ignore it or don't give a sufficient response, that would be considered dishonor. Okay. And the key to discharging debt, and I'll jump the gun a little bit, is putting them in a position where they have dishonored you. Because if they dishonor you, then whatever they claim that you owe pretty much like is null and void. Because if you are moving with honor, then me asking you particular questions about the contract, if it is unable to be answered, that is not my fault. Okay? You have a duty to do that. So if you don't do your duty, then you will be dishonoring the contract. You'll be dishonoring me. You're not moving honorably. Okay? Because even when we talk about trust law, I mean, it's in the name, trust. Okay? So it's about trust. Okay? So let's just talk a little bit about the legal foundation behind this. Okay? So if I pull up UCC 3-501, it says a presentment means a demand made by or on behalf of a person entitled to enforce an instrument. Okay? And we'll just stop there. We aren't going to read all of this. But it says a presentment is a demand. So when you are presenting something, especially when you are presenting a conditional acceptance letter, or you are presenting a debt validation letter, or you are sending them any type of affidavit, communicating with them, and you're asking them for particular things, it's not that you are like really asking for permission. It's a demand. Okay. If this demand goes, ignored, then that will be considered dishonor. It also breaks down. So this breaks down what a presentment is. So obviously taking a look at UCC 3-501, understanding the power of a presentment is important. But then you go to UCC 3-505, evidence of dishonor, explains what dishonor is, which is everything that I just explained prior. Okay, so this is the legal merit behind the evidence of dishonor. But then you can also go to UCC 1-202, which is not something I particularly talked about on this page. It says what the definition of notice. A person has to notice a fact if the person has actual knowledge of it, has received the notice or notification of it from all the facts and circumstances known to the person at the time in question, has reason to know that it exists. Okay, knowledge means actual knowledge. Knows has a corresponding meaning. Discover, learn, or words similar import refer to knowledge rather than to reason to know. That was very interesting how they kind of put it. Why? This is why you got to just, try not to just read it for face value. It may confuse you. A person notifies or gives a notice or notification to another person by taking such steps as may be reasonably required to inform the other person in ordinary course, whether or not the other person actually comes to know of it. Okay? And it seems like they're just going to keep like saying the same thing over and over and over again in different ways. But when you think this is pretty much breaking down what a notice is, okay, and what a response is and how someone should respond to your notice. Okay. Another thing I want to break down is the aspect of tacit agreement. If you, let's just say they create a contract, or let's just give an example of how we tacitly agree. When we get a debt collection letter and saying that we owe X amount of dollars, one of the ways that we tacit agree is by not responding. Okay, meaning we'll get bills in the mail, take a look at them, and cower away from them, thinking that that's going to help it. Ignoring it is going to help it. But when you ignore it, you're actually doing the wrong thing by, number one, not by dishonoring it. Okay. And number two, you give them the ability to assume your agreement. Okay. In order to avoid a tacit agreement, any presentment that you get, you kind of want to respond back. Okay. If it is a 10 grand that you want to get validated, the way you want to respond back to a collection letter is by sending them a debt validation letter, asking them and inquiring about the debt, especially if one of the things you don't want to do is automatically agree. Okay. If that's what you want to do, like if you decide, okay, I'm going to delay paying this, right? Let's just say maybe by chance, and given a real world example, you don't want to pay your debt right now. Okay. you can just go straight by sending them a debt validation letter or giving them some level of response to their collection letter, so that number one, you don't dishonor and you're moving honorably. And number two, you don't just automatically agree to paying the debt right away. Okay. Now, debt validation, that's in the Fair Debt Collection Practices Act, is something that you can do. So for my new people that aren't tapped into the Fair Debt Collection Practices Act, take a look at it. But you can validate any and all debt. I don't care if it comes from your mortgage company, your auto loan company, a collection agency, your utility bill, whatever the case may be. But if you do decide to do it, you have to be strategic when doing that. Okay. In commerce, when you don't respond, you pretty much are agreeing. And that's just the law of commerce. Okay. You can hate it, you can dislike it, but just play the game properly. Okay. Now, here's how to create the opportunity for dishonor. Now, when you create an opportunity for dishonor, or you put them in a position where they have dishonored you, that actually gives you a better and a more advantageous position. Okay. So if you wanted to have them dishonor, right? Or for my people that say, oh, they ignore me and this, that, and the third, we're going to talk about how this actually is an opportunity for you versus something that's actually keeping you from getting remedy. Okay. I think a lot of people think that if they don't respond, then it doesn't work. No, if they don't respond, it's more likely because what you are doing is working. And what happens is they are just moving untrustworthily, if that's a proper word. They're moving in dishonor. And that right there is why you are in such a great position to be able to challenge the debts and be able to challenge the contract itself. If it's a proper and honorable contract, then just move honorably. And if I'm asking you for the accounting, or I'm asking you to validate debt, or I'm asking you to prove that you're the legal holder in due course, if I'm asking you if you still have the title to the obligation, if I'm asking you for the source of funds, if you did things honorably, wouldn't you just give it to me? Just plain and simple. That this is exactly why they can have an argument. Their only argument is that you agreed to pay. Okay. But if you debunk that agreement to pay by literally sending them a conditional acceptance, shifting the burden of proof onto them, saying, hey, look, I will agree to pay X, Y, and Z if you can prove this, and they don't do that, then you really don't want your money, right? Or maybe you don't need the money. Okay. Maybe it's just something that it's not even about the money for y'all. Maybe it's more of a mental thing for y'all. Okay. So step by step, this is how you're going to have them dishonor. Number one. Okay. You're going to send them a proper notice. Okay. Whether it's an offer, an affidavit, or a demand presentment. Okay. Whether it's a conditional offer, whether it's a lawful tender, whether it's a demand, using the UCC, okay? Whether it's an affidavit of truth, you have to properly set up by sending a proper notice, okay? A lot of times people just send a tender, right? A lawful tender, but they don't send a notice with it, a presentment, a demand, an affidavit with it. So this is how you're going to start off. The reason why you do that, because in this affidavit, you're going to state a deadline clearly, whether they have 10 days to respond, 72 hours, 30 days, 15 days to respond. Okay. Because if they don't respond to that deadline that you clearly and conspicuously put in your letter or your notice, then they would be dishonoring you. And you're letting them know, hey, if after 10 days go by and you do not respond, I'm going to assume your agreement, or I will take it as dishonor. You dig what I'm saying? So it shouldn't be, for my people that may have the question of what should I do next, it shouldn't be a question of what I should do next. It should be more of a question of why, like, I gave you guys clear instructions. You should already put in the letter what will happen when they decide to ignore you. If you decide to ignore me, or if this goes unrebutted, everything stands in truth. If you ignore me, I'm going to assume it's discharged or refused. And a refusal under UCC 3-603 means that it's discharged. Okay? You also want to send your notice certified or registered, depending on whether you're sending a security. Certified, as long as you send it certified, you should be good. And if you do get it notarized, that also gives you a better case as well. Because if somebody witnesses you send this and you have the mail tracking, then you have proof that you have sent them something on a timely manner, and you now in your letter gave them clear instructions on what you want them to do over the next 10, 15, or 30 days. If they decide not to do it, then that is pretty much they're willfully dishonoring you. Okay. And number 4, you want to make sure to document every step with copies, mailing receipts, timelines. You want to create what's called like an evidence binder and put all your presentments in one, whether you want to split them up between different creditors or debt collectors or credit bureaus, right? Or you want to put it all in one binder. Just make sure it's organized. But this is how you want to make sure that you are building a case towards dishonor, because this is what to expect. A lot of times people don't expect to they're expecting them to move honorably when they're not. You guys gathering that? Okay. Now, it's important that you are lawful, that you're being specific, and you give them a chance to respond. Okay. Lawful, specific, and give them that opportunity to respond, because you're moving in honor. You're not trying to use the same undercut methods that they are using. You're going to move morally. Okay. Number 2, you want to avoid being vague or unenforceable. Okay. Be clear about your intentions. That's another thing that we struggle with, is when we do send our letters, we're too vague. No, be specific. In order to be prolific, you must be specific. My bad. Okay. Dishonor isn't just silence, it's a failure to respond to a claim with equal or superior evidence. Okay. So there's an aspect of them having to move sufficiently. They can't just ignore your presentment, or they can't just send you BS and call that a response. No, their response has to align with what you asked them for or demanded them of, order them to do. But a lot of times they'll just send you something to stall you, and you'll think, or most of us will think, hey, well, they responded, so how do I respond to their response? No, you clearly know what you sent them and asked them for, and then you ask yourself, did they give you what you asked them or demanded them of? Because if they didn't, that is dishonor. Someone will say, well, they said I couldn't do this. That is a dishonor, because that's not what I asked you. I didn't ask you to tell me I couldn't do this, because I know I can. So what are you telling me I couldn't do this and just not complying to the UCC or your duties as a debt collector, as a lender, or as a credit bureau? Okay, this also goes along with the credit bureaus as well. Okay, if the credit bureau ignores you, that is also dishonor. Even when I'm speaking with my clients, right, they'll get a stall letter from the credit bureau, and they're in an uproar. Why they didn't respond, or whatever the case may be. And I say, well, no, that's exactly what we want. I expected them not to respond, but that just makes your case better. That makes our case better. Okay. So this is how you're going to document the dishonor properly. We're going to go ahead and wrap this up, because I do got to go in a few. Okay. Number 1, you want to use tools like affidavits of non-responses. You want to put them on notice and say, hey, I noticed that you didn't respond. Okay. You want to send a notice of fault and an opportunity to cure. You want to give them that opportunity to cure, so that you are continuing to move in honor. Hey, maybe you missed this. Maybe you didn't see that I asked you this particular question, so I'll ask it again, and I'll include my last presentment, my last demand as an exhibit, so that you can review it again. Because we're not going to sit here and fly and make it seem like you're I don't know what I'm talking about. You know what I mean? I'm not going to sit here and act like you are moving compliantly, if that's a word. Okay. You can also send something like a certificate of non-performance, because remember, when you send a notice or offer, you have created a contract for them to perform, and either, because it was a demand or an offer, either to accept, reject, or counter offer, or on the other foot, to perform in a way to provide whatever data you're asking for, whatever information you are asking for, as it pertains to the loan in compliance with the UCC and the law. Okay. And any notary certificate of service or protest or whatever the case may be that enhances and also shows witness of you providing the mailing it to them, signing off this document, or whatever the case may be. You want to include, when you in your documentation, the dates of the original notice, any tracking numbers, the exact language from your offer or tender, and you want to put any evidence of silence, refusal, or default and pair it up with UCC 3-603 or any other laws that are in connection with that response, okay? Because the paperwork is the proof. The paperwork is what's going to tell the story, okay? It's going to bring evidence to the story. So when you go in there, you're not just spouting out, hey, well, I shouldn't have to pay this, that, and the third. No, I feel like I shouldn't have to pay it, or I didn't pay it because I asked them for particular information, and I'm moving properly as it pertains to a contract, and they dishonored me. So that's why I stopped paying them. Why would I pay someone who is moving dishonorably? Why would I pay somebody that is trying to manipulate or put me in a position that is adverse to me? Because all I'm asking is something that I can ask. Why would they have this in the Constitution if I couldn't ask this? Why are you above the Constitution? Okay? Now, these are not things you just go and you argue with them about. No, you just execute the process, and the story's going to tell itself. These are things that you need to understand for your own self so that you can have confidence to actually do it. I think a lot of times people may know how to do it, but they don't have confidence because whatever reason, okay? Now, don't get me wrong. It may be tough, right? But if you truly want to get the result, a remedy, if your back is really in the corner and you can't do anything, paid or whatever the case may be, then you should do anything and everything in your power to challenge the debt or overcome, them taking advantage over you. Okay. So here are some examples. If a debt collector doesn't validate under 15 U.S.C. 1692G, you issue a notice of default. You say, hey, look, you have defaulted. I literally clearly asked you for you to validate the debt, and you decided not to. So there it is. You have defaulted on that contract. Okay. But then we dive into if a judge refuses, let's say you go into court and then you ask the judge to provide that jurisdictional proof. You want to document that refusal, and you want to object for the record, okay? Whether they accept it or not, put it on the record because it'll create a paper trail in case you want to appeal, all right? Now, dishonor flips the burden, and you're no longer proving anything they actually are, okay? Another thing, all right? Dishonor is literally how you're going to win. When it comes to debt discharge, I think a lot of times people think it's about the negotiable instruments and the promissory notes, and it's about doing some secret TDA account, using your SSN routing number, creating a bill of exchange. But the true power is going to come in putting them in a position where they have dishonored you, because whether or not if you are in a contract and they are not moving honorably, then that contract becomes unenforceable. This is it right there. It's a contract battle. It's not about you paying a debt. It's a contract battle. You guys gather that? All right. So I wanted to cover that today. I'm getting a phone call from my family about to start communion with my family. So they're calling me right now. So I'm gonna go ahead and wrap this up. If you want to learn more about this, down below, you can go ahead and tap in with the Complete That Guide /school community. You tap into the school community, you get to Complete That Guide and any other types of topics about credit, funding, whatever the case may be. Tap in to the school community down below. Okay, it's less than $1 a month, less than $1 a day. Tap in, you can get it on the free trial for the next 7 days. Okay. Number 2, if you want to work with me one-on-one, as opposed to fixing your credit, getting funding, tap into that one-on-one link. That's as if you want to work with me one-on-one, and trust and believe it is a private coaching experience. So it is something premium and is not for everybody. Okay. But if you're serious, tap into that and apply. Number 3, tap into my Instagram at biz.nick. Tap into my Twitch at biz_nick. Make sure to stay tapped in. Okay. Because that's where we either go live or communicating on a consistent basis. Okay. Drop a comment if you ever sent the letter and got no response and want to know what to do next. Tell me exactly what your experience is, and anybody who is going through this right now, what are you doing? Okay? Remember to like, subscribe, hit the bell. Remember to hit that post notification bell. If you've gotten this far, comment the word discharge, and I'll see you in the next video.